Chapter 5: Law and the State. Legal intercourse does not, quote, naturally presuppose a state of peace, just as trade does not in the first instance preclude armed robbery, but goes hand in hand with armed robbery. Law and self-help, those seemingly contradictory concepts, are in reality extremely closely linked. This is true not only of the most ancient epoch of Roman law, but also of later periods. Modern international law includes a very considerable degree of self-help, retaliatory measures, reprisals, war, and so on. Even in the, quote, well-ordered, end quote, bourgeois state, rights are secured in the opinion of an astute jurist like Hariu by every citizen at his own risk. Marx formulates this even more succinctly in his, quote, in his introduction to the Critique of Political Economy. Quote, even club law is law, end quote. This is not a paradox, for law, like exchange, is an expedient resorted to by isolated social elements in their intercourse with one another. At different stages of history, this isolation can be more or less pronounced, but it can never vanish altogether. Thus, the enterprises belonging to the Soviet state, for example, actually fulfill a communal task, yet because in their work they are forced to adhere to market methods, each one of them has separate interests. They confront one another as buyers and sellers, do business at their own risk, and as a result must inevitably engage in legal intercourse with one another. The ultimate victory of planned economy will transform the relationship into an exclusively technical expedient, thereby doing away with their, quote, legal personality, end quote. Therefore, whenever people portray legal intercourse as organized and well-ordered, and thus equate law with legal order, they forget in so doing that this order is actually a mere tendency and end result, by no means perfected at that, but never the point of departure and prerequisite of legal intercourse. The very state of peace which to abstract legal thought seems homogeneous and undifferentiated, was not so at all in the early stages of legal development. Ancient Germanic law recognized varying degrees of peace. Peace in the household, peace within the enclosure, peace within the boundaries of the settlement, and so on. The greater or lesser degree of pacification was expressed in the varying severity of the punishment meted out to the person guilty of a breach of the peace. The state of peace becomes a necessity when exchange becomes a regular phenomenon. In cases where there were insufficient preconditions for keeping the peace, the persons engaged in exchange preferred to each inspect the commodities separately, in the absence of the other party, rather than meeting together personally. In general, however, trade requires that not only the commodities, but the people too come together. In the epoch of the gens system, every stranger was regarded as an enemy. He was free game, just like the beast of the forest. Only the custom of hospitality provided an opportunity for intercourse with alien tribes. In feudal Europe, the church attempted to check the incessant private wars by proclaiming the so-called Troika die, or Troika die, at certain intervals. Simultaneously, markets and training centers began to be endowed with appropriate special concessions. Merchants going to market received safe conduct. Their property was protected against arbitrary seizure. At the same time, the fulfillment of contracts was guaranteed by special judges. In this way, a special jus mercatorum, or jus fori, rose, which formed the basis of later municipal law. Originally, marketplaces and fairs were part and parcel of the feudal domains. and were simply advantageous sources of income for the local feudal lord. Whenever a place was granted market peace, the sole purpose of this was to fulfill the purpose of some feudal lord, so that it was in his private interest. Yet thanks to its new role as guarantor of the peace, indispensable to the exchange transaction, feudal authority took on a hue which had hitherto been alien to it. It went public. The feudal or patriarchal mode of authority does not distinguish between the private and the public. The feudal lord's public rights with regards to his serfs were simultaneously his rights as a private owner, whereas his private rights, on the contrary, may be interpreted, if one so wishes, as political and therefore public rights. This is exactly the way in which many people, including Gomplowitz, interpret the jus civile of ancient Rome as a public law, since it was founded on and originated in membership of a gens organization. In fact, we are faced here with an embryonic form of law which has not yet developed within it the contradictory yet correlate determinants, quote, private law and, quote, public law. This is why any form of power which bears traces of patriarchal or feudal relations is also characterized by the predominance of theological rather than legal aspects. Only the development of trade and of the money economy make the juridical or rationalistic interpretation of the phenomenon of power possible. It is these economic forms which first introduce the contradiction between public and private life, a contradiction which assumes, over time, a, quote, eternal and, quote, natural character, and forms the basis of every juridical theory of power. The, quote, modern state, in the bourgeois sense, comes into being at that point in time when the organization of power by groups or classes encompasses a sufficiently expanded activity in market transactions. Thus, in Rome, trade with foreigners, resident aliens, peregrini, and others demanded acknowledgement of legal capacity in the civil sphere in people who were not members of the gens association. This already presupposes, however, a distinction between public and private law. The earliest and most complete separation between the public law principle of territorial sovereignty and private land ownership occurs in medieval Europe, within the city walls. It is there that the material and personal obligations pertaining to land disintegrate earlier than anywhere else into taxes and obligations in favor of the municipality on the one hand and into rent based on private property on the other. Effective power acquires a markedly juridical, public character as soon as relations arise in addition to and independently of it, in connection with the act of exchange, that is to say, private relations par excellence. By appearing as a guarantor, authority becomes social and public, an authority representing the impersonal interest of the system. The state, as an organization of class rule and for waging external wars, neither needs nor admits of any legal interpretation. This is an area where so-called raison d'etat holds sway, which is nothing but the principle of naked expediency. In contrast to this, power as a guarantor of market exchange not only employs the language of law, but also functions as law and law alone. That is, it becomes one with the abstract objective norm. Consequently, every juridical theory of the state, which attempts to encompass all state functions, is nowadays inadequate. It cannot accurately reflect all the facts of state life. It gives a purely ideological, that is, a distorted reflection of reality. Class rule, both in its organized and its unorganized forms, is much more far-reaching than the sphere which can be designated as the state authorities official sphere of jurisdiction. The dominance of the bourgeoisie is expressed in the dependence of governments on banks and capitalist associations. The dominance of the bourgeoisie is expressed in the dependence of governments on banks and capitalist associations, and in the dependence of every individual worker on his employer, as well as in the fact that the personnel of the civil service is closely interlinked with the ruling class. All these facts, and there are any number of them, have no kind of official legal expression at all. Yet in their consequence they coincide with the facts that do indeed find official legal expression in the subordination, for instance, of those very workers to the laws of the bourgeois state, to the orders and decrees of its organs, to the sentences of its courts, and so on. Thus there arises, besides direct unmediated class rule, indirect, reflected rule in the shape of official state power as a distinct authority detached from society. This raises the problem of the state, which poses no lesser difficulties for analysis than the problem of the commodity. In his Origins of the Family, Private Property, and the State, Engels regards the state as the expression of the fact that society has become entangled in insoluble class antagonisms. Quote, "But in order that these antagonisms, classes with conflicting interests, might not consume themselves and society in fruitless struggle, it became necessary to have a power seemingly standing above society that would alleviate the conflict and keep the conflict within the bounds of, quote, order. And this power, arisen out of society but placing itself above society, and alienating itself more and more from society, is the state." End quote. A part of this argument, end quote, Engels. A part of this argument is not quite clear, as will become apparent in what follows. Engels maintains that state power of necessity falls into the hands of the most powerful class, quote, "which through the medium of the state becomes also the politically dominant class," end quote. This proposition gives rise to the assumption that state power comes into being, not as a class force, but as something standing above classes, saving society from disintegration and becoming the object of usurpation only after its emergence. Such a conception would, of course, fly in the face of historical facts. We know that the machinery of power has always been created by the ruling class. It is our opinion that Engels would himself have rejected such an interpretation of his words. Be that as it may, the formula posited by Engels still remains unclear. According to this formula, the state emerges because the classes would otherwise mutually destroy one another in bitter struggle, wrecking the whole of society in the process. It follows that the state emerges in a situation where neither of the two conflicting classes is in a position to force a decisive victory. This implies either that the state perpetuates the relationship of equilibrium and is therefore a force standing above the classes, which we cannot admit, or that it is the result of the victory of one class or another. However, were the latter true, society would have no further need for the state, since the decisive victory of one class would restore equilibrium, thus saving society. All these controversies mask one and the same fundamental question. Why does class rule not remain what class rule is? The factual subjugation of one section of the population by the other. Why does class rule assume the form of official state rule? Or, which is the same thing, why does the machinery of state coercion not come into being as the private machinery of the ruling class? Why does it detach itself from the ruling class and take on the form of an impersonal apparatus of public power, separate from society? It is not enough to confine ourselves to pointing out that it is advantageous to the ruling class to erect an ideological smokescreen and to conceal its hegemony beneath the umbrella of the state. For although such an elucidation is undoubtedly correct, it still does not explain how such an ideology could arise, nor, therefore, does it explain why the ruling class has access to it. For the conscious exploitation of ideological forms is of course something separate from their emergence, which usually occurs independently of people's will. If we wish to expose the roots of some particular ideology, we must search out the material relations which it expresses. In the process, we shall moreover encounter one of the fundamental differences between the theological and juridical interpretation of the concept of state power. In the former interpretation, the theological interpretation, we are dealing with fetishism of the first order. Consequently, we shall not succeed in discovering anything at all in the corresponding ideas and concepts other than an ideological reproduction of reality. In other words, the same factual relations of dominance and subservience. In contrast to this conception, the legal view is one-dimensional. Its abstractions are the expression of only one of the facets of the subject as it actually exists, that is, of commodity-producing society. In his book, Problems of the Marxist Theory of Law, Razumovsky accuses me of transposing questions of dominance and subservience to the ambiguous realm of the, quote, reproduction of reality, end quote, and not of granting them their rightful place in the analysis of the category of law. It seems to me that after Feuerbach and Marx, there is no longer any need to debate the fact that religious or theological thought represents a, quote, duplication of reality, end quote. I do not see anything ambiguous in that. On the contrary, the facts of the matter are transparently clear. The serf's subjugation by a feudal lord was the direct and unmediated result of the feudal lord being a landowner with an armed force at his disposal. This direct dependence, this signorial relation, increasingly assumed an ideological veneer, with the feudal lord's power being increasingly deduced from a divine, superhuman authority. Quote, no power if not God-given, end quote. The wage laborer's subjection to and dependence on the capitalist has a similar immediacy. Congealed dead labor here dominates living labor. Yet this worker's subjugation by the capitalist state is not a mere ideological duplication of his dependence on the individual capitalist. It is not the same, firstly, because we have here a special apparatus, separate from the representatives of the ruling class, which stands above every individual capitalist and functions as an impersonal force. Secondly, it is not the same because this impersonal force does not mediate every individual exploitative relation. The wage worker is not actually politically and legally compelled to work for a particular entrepreneur. Rather, he formally sells that entrepreneur his labor power on the basis of a free contract. Insofar as the exploitative relation exists formally, as a relationship between two autonomous and, quote, equal owners of commodities, of whom one, the proletarian, sells his labor power, and the other, the capitalist, buys that labor power. Political class power can take on the form of a public authority. Insofar as the exploitative relation exists formally as a relationship between two autonomous and equal owners of commodities, of whom one, the proletarian, sells his labor power, and the other, the capitalist, buys that labor power, political class power can take on the form of a public authority. As we have already said, the principle of competition prevailing in the bourgeois capitalist world does not allow any possibility of linking political power to the individual economic enterprise in the way in which this power was linked to landed property under feudalism. Quote, free competition, the freedom of private property, quote, equality in the market, and the monopolization of the means of production by one class combine to produce a new form of state power, democracy, which enables that class to come to power collectively. End quote. Podvolotsky. It is quite true that, quote, equality in the market creates a specific form of power, but these phenomena are connected in quite a different way than Podvolotsky thinks. To begin with, power can remain the private affair of capitalist organizations, even without being linked to the individual enterprise. The industrial associations, with their fighting funds, their blacklists, their lockouts, and their regiments of strikebreakers, are undoubtedly organs of power which coexist with public, that is, with state power. Moreover, control within the enterprise remains the private affair of each individual capitalist. The establishment of labor regulations is an act of private legislation. In other words, it is a piece of pure feudalism. This remains true despite the lengths to which bourgeois jurists go in order to tart it up in a modern fashion by creating the fiction of the so-called contrat d'adhésion, or of a special mandate which the capitalist is supposedly granted by the organs of official power, so that he may, quote, successfully perform the socially necessary and expedient functions of the enterprise. End quote. The analogy with feudal relations is nevertheless not absolutely apposite in the given example, for as Marx says, quote, the authority assumed by the capitalist as the personification of capital in the direct process of production, the social function performed by the capitalist in his capacity as manager and ruler of production, is essentially different from the authority exercised on the basis of production by means of slaves, serfs, etc. On the basis of capitalist production, the mass of direct producers is confronted by the social character of their production in the form of strictly regulated authority and a social mechanism of the labor process organized as a complete hierarchy. This authority reaches its bearers, however, only as the personification of the conditions of labor in contrast to labor, and not as political or theocratic rulers as under earlier modes of production. End quote. Marx, Capital, Volume 3. Thus it is possible for the relations of dominance and subservience to exist in the capitalist mode of production too, without deviating from the concrete form in which these relations figure, as the domination of the producers by the conditions of production. Yet precisely the fact that they do not appear in veiled form here, as they do in slavery and serfdom, makes them incomprehensible to the jurist. To the extent that society represents a market, the machinery of state is actually manifested as an impersonal collective will, as the rule of law and so on. Every buyer and seller is, as we have seen already, a legal subject par excellence. The autonomous will of those engaged in exchange is an indispensable precondition wherever the categories of value and exchange value come into play. Exchange value ceases to be exchange value, the commodity ceases to be a commodity, if exchange ratios are determined by an authority situated outside of the internal walls of the market. Coercion as the imperative addressed by one person to another, and backed up by force, contradicts the fundamental precondition for dealings between the owners of commodities. In a society of commodity owners, within the limits of the act of exchange, coercion is neither abstract nor impersonal, hence it cannot figure as a social function. For in the society based on commodity production, subjection to one person as a concrete individual implies subjection to an arbitrary force, since it is the same thing for this society as the subjection of one owner of commodities to another. This is also why coercion cannot appear here in undisguised form as a simple act of expediency. It has to appear rather as coercion emanating from the abstract collective person, exercised not in the interest of the individual from whom it emanates, for every person in commodity-producing society is egoistic, but in the interest of all parties to legal transactions. The power of one person over another is brought to bear in reality as the force of law, that is to say, as the force of an objective, impartial norm. Bourgeois thought, which takes the framework of commodity production for the eternal and natural framework of every society, therefore regards abstract state power as an apputurance. Regards abstract state power as an apputurance. Bourgeois thought, which takes the framework of commodity production for the eternal and natural framework of every society, therefore regards abstract state power as an appurtenance of any and every society. This is most naively expressed by the theoreticians of natural law, who base their theory of power on the idea of the intercourse between autonomous and equal personalities, and imagine that in so doing, they are proceeding from the principles of social intercourse as such. In fact, all they have developed in various keys is the theme of a power representing the connecting link between autonomous owners of commodities. This explains the fundamentals of this doctrine, which are evident as early as Grotius. For the market, what really matters is that the commodity owners should engage in exchange. The power structure is something secondary and derived, externally imposed on the existing commodity owners. This is why the theoreticians of natural law do not regard state power as a phenomenon which arose historically, and is therefore bound up with forces at work in the society in question, but think of state power rather in an abstract and rationalistic manner. In intercourse between commodity owners, the necessity for authoritarian coercion arises whenever the peace is disturbed or a contract not fulfilled voluntarily. The doctrine of natural law, therefore, reduces the function of state power to keeping the peace, and sees the state's sole determining feature as being the instrument of law. After all, in the market, one owner of commodities is a commodity owner by the consent of the others, and all of them are commodity owners through their collective will. This is why the theory of natural law deduces the state from the contract between isolated individuals. This is the entire theory in skeleton form, which admits of the most diverse concrete variations, depending on the historical position or the political sympathies and dialectical abilities of any one author. It allows of republican as well as monarchist deviations, and of altogether the most varying degrees of democratic and revolutionary, quote, isms. On the whole, though, this theory was the revolutionary banner under which the bourgeoisie fought out its revolutionary struggles against feudal society. That also decided the fate of the theory. Since the bourgeoisie became the ruling class, the revolutionary past of natural law has begun to arouse apprehension, and the prevailing theories cannot wait to consign natural law to oblivion. Of course, the theory of natural law does not stand up to any kind of historical or socialist critique, for the picture natural law paints in no way corresponds to reality. Yet the odd thing is that the juridical theory of the state, which supersedes the natural law theory of the state, and which dispensed with the doctrine of the inherent and inviolable rights of people and citizens, thus acquiring the label positive, distorts actual reality just as much as its predecessor. It is forced into this distortion because every juridical theory of the state must of necessity posit the state as an independent power separated from society. It is this which constitutes the juridical nature of the theory. Although in fact the activity of state organizations goes on in the shape of decrees and edicts emanating from individuals, juridical theory assumes firstly that the state, not individuals, issues these orders. Secondly, that these orders are subordinate into the general norms of the code, which in turn expresses the will of the state. On this point, the theory of natural law is not one whit more fanciful than any of the juridical theories of the state. Even the most positive of them, for the substantive element in the doctrine of natural law was that it posited, in addition to the various forms of mutual personal dependence, from which this doctrine abstracts, another form of dependence on the impersonal collective will of the state. Yet just this construct also forms the basis of the legal theory of the, quote, state as a person, end quote. The element of natural law in the juridical theory of the state lies much deeper than was apparent to the critics of the doctrine of natural law. It lies in the very concept of public authority, that is, of an authority which belongs to no one in particular, stands above everyone, and addresses itself to everyone. In using this concept to orient itself, juridical theory inevitably loses touch with actual reality. The difference between the doctrine of natural law and most recent legal positivism consists only in the fact that the doctrine of natural law is much more clearly aware of the logical connection between abstract state power and the subject in the abstract. Natural law theory grasped the necessary connection between these mystically veiled relations of commodity-producing society, and hence provided an example of classical clarity of construction. In contrast to this, would-be legal positivism is undecided even about its own logical premises. The constitutional state, the Rechtsstaat, is a mirage, but one which suits the bourgeoisie very well. For it replaces withered religious ideology and conceals the fact of the bourgeoisie's hegemony from the eyes of the masses. The ideology of the constitutional state is even more convenient than religious ideology, because while the ideology of the constitutional state does not entirely reflect objective reality, it is still based on this reality. Power as the, quote, collective will, end quote, as the, quote, rule of law, end quote, is realized in bourgeois society to the extent that this society represents a market. From this point of view, even police regulations can figure as the embodiment of the Kantian idea of freedom, limited by the freedom of others. The free and equal owners of commodities who meet in the market are free and equal only in the abstract relation of appropriation and alienation. In real life, The free and equal owners of commodities who meet in the market are bound by various ties of mutual dependence. Examples of this are the retailer and the wholesaler, the peasant and the landowner, the ruined debtor and his creditor, the proletarian and the capitalist. All these innumerable relationships of actual dependence form the real basis of state structure, whereas for the juridical theory of the state, it is as if they did not exist. Further, the life of the state consists of the struggle between various political forces, between classes, parties, all manner of groupings. It is here that the real mainsprings of the machinery of state lie hidden. To juridical theory, they are just as incomprehensible as the relationships mentioned above. The jurist may well be able to show a greater or lesser flexibility and ability to adapt to the facts. He can, for example, also take into account, besides statute law, the unwritten rules which have gradually arisen in the course of state practice. But that does not alter anything in principle in his fundamental approach to reality. A certain discrepancy between legal truth and the truth to which historical and sociological research aspires is unavoidable. This is due not only to the fact that the dynamic of social life overturns rigidity. This is due not only to the fact that the dynamic of social life overturns rigidified legal forms, and that, as a result, the jurist is condemned always to complete his analysis far too late, even if he does remain up to date with the facts in his assertions. He renders these facts differently than the sociologist. For so long as he remains a jurist, he starts from the concept of the state as an autonomous force, set apart from all other individual and social forces. From the historical and political point of view, the resolutions of an influential class or party organization have a significance as great and sometimes greater than the decisions of Parliament or of any other state organization. From the legal point of view, facts of the first kind are, as it were, non-existent. In contrast to this, one can, by ignoring the legal standpoint, see in every parliamentary resolution not an act of state, but a decision reached by a particular group or clique, acting in accordance with individual egoistic or class-oriented motives, like every other collective. The extreme normativist Kelsen concludes from this that the state exists only in theory, as a closed system of norms or obligations. Such immateriality in the object of the theory of constitutional law must indeed alarm the practical jurist, for they sense, if not with their reason, then with their interest, the undoubted practical validity of their concepts, precisely in this wicked world, and not in the sphere of pure logic alone. The, quote, state, end quote, of the jurist is linked, despite its, quote, ideological nature, end quote, to an objective reality, just as the most fantastic dream is still based on reality. This reality is primarily the machinery of state itself, with all its material and personal elements. Before creating internally consistent theories, the bourgeoisie first constructed its state in practice. This process was inaugurated in the municipalities of Western Europe. Whilst the feudal world made no distinction between the personal resources of the feudal lord and the resources of the political organization, in the cities there arose, at first sporadically, and later as a permanent institution, the communal city purse. The spirit of, quote, statedom, end quote, is given, so to speak, its material basis. The establishment of state financial resources encouraged the appearance of people who lived from these means, officials and functionaries. In the feudal epoch, administrative and judicial functions were performed by servants of the feudal lord. Public offices in the true sense of the word first appeared in the municipalities, Public offices are the material embodiment of the public nature of power. Authorization in the private law sense of a mandate to conclude legal transactions becomes separated from public office. Absolute monarchy needed only to usurp this public form of power, which had originated in the cities, and to apply it to a wider area. Every additional improvement in bourgeois statedom, whether achieved by revolutionary outbreaks or by peaceful adaptation to feudal monarchist elements, can be traced back to a single principle, according to which neither of two people exchanging in the market can regulate the exchange relation unilaterally. Rather, this requires a third party who personifies the reciprocal guarantees which the owners of commodities mutually agree to as proprietors, and hence promulgates the regulations governing transactions between commodity owners. The bourgeoisie based its theories on this juridical concept of the state, which it attempted to put into practice. In the process of this realization, however, the bourgeoisie allowed itself to be guided by the notorious principle, quote, just as it has been done in the past, so it shall be done in the future, end quote. For the bourgeoisie has never, in favor of purity of theory, lost sight of the fact that class society is not only a market where autonomous owners of commodities meet, but is at the same time the battlefield of a bitter class war, where the machinery of state represents a very powerful weapon. On this battlefield, relations do not appear to be the least in the spirit of Kant's definition of law as a minimal limitation of the freedom of the personality indispensable to human coexistence. Gumplowitz is right here when he claims that this kind of law never existed, for, quote, the measure of some people's, quote, freedom, end quote, is solely dependent on the measure of their domination by others. The norm is determined not by the possibility of coexistence, but by the domination of some by others, end quote. Gumplowitz. The state as a power factor in internal and foreign policy, that is, the correction which the bourgeoisie was forced to make to the theory and practice of its, quote, constitutional state, end quote. The more the hegemony of the bourgeoisie was shattered, the more compromising these corrections became. The more quickly the, quote, constitutional state, end quote, was transformed into a disembodied shadow, until finally the extraordinary sharpening of the class struggle forced the bourgeoisie to discard the mask of the constitutional state altogether, revealing the nature of state power as the organized power of one class over the other.